Well, she's back. Our resident lawyer, Despina Priala of boutique law firm Priala Legal in Runaway Bay, with us every Thursday, except last one, to offer her legal expertise by providing some general advice on the latest hot topic. She has experience that spans more than 25 years in the area of property and commercial law. She also prepares wills as part of estate planning and litigation. With us once again after a brief sojourn. Good morning to you. How are you going, Despina?
Good morning, Wayne. Good morning, Brooke. I'm doing really well after this week's the Melbourne Cup. How about you?
Did you find a winner?
I did in the sweeps. So I was lucky that way. But of course,
Yeah.
my own personal bets, no go.
No go. Yeah, no, if you're on the favourite, you missed out big time, but it was just such a lottery. So, no, if you're amongst the money in if you're amongst the money in Tuesday's Melbourne Cup, it was pure luck.
Yes, exactly, definitely.
Well,
But good to be back.
so happy to have you back. And of course, we have some hot topics lined up as usual. This one to kick off, I love this one. It's all about, so it's something local and it can apply to majority of people if you've ever lived in an apartment or under a body corporate. There was a recent case regarding a body corporate not seen to be acting reasonably. It's a very interesting case, Despina. There was an outcome. Can you talk us through what happened?
Yeah, I'd love to do that. And as we talked a couple of weeks ago, if you remember, we talked about the new pet tenancy laws. And of course, we're talking about any tenancy, but here we're talking about bodies corporate. Okay, so this could easily flow on to what we talked about 2 weeks ago with the new pet tenancy laws, and what a landlord can or cannot impose, or what would be considered as a reasonable condition to have a pet in the dwelling. Now here, it of course equally applied to a body corporate situation, and this particular case came out of the adjudicator's office on the 7th of October it was. I'm just reading the case in front of me here. So this involved a building up at Wooloongabba in Brisbane, and it was a 46 lot building, and what was the interesting part here, and that's why I picked up on this case when it came across my desk from what we talked about 2 weeks ago with the new pet tenancy laws, is that this particular body corporate involved here was trying to, as part of the conditions to a lot owner having a dog, what they did is that they said, okay, as part of the conditions, we want your dog to wear a muzzle. Okay.
Oh.
Yes. And you can imagine straight away all those people listening out there that are dog lovers. You can imagine immediately they'll be going, oh, yes, I would never want my dog to be forced to wear a muzzle in a building like where I live.
Cool.
So I thought, well, this is a great case to talk about, and to talk about the ins and outs of what the adjudicator looked at, and how it came to the decision. So I will say, in short, the decision was made that it was unreasonable for the dog to be wearing a muzzle as a condition, right? To have the dog in the lot. So that was the short of it. But we want to talk about the ins and outs, because you might have listeners out there that might be in the situation which this particular person found himself to be, where the body corporate was seen to be acting unreasonably. Okay. And wouldn't be the first time, if I can say, that a body corporate has acted unreasonably, particularly on the Gold Coast or Queensland, throughout, where they've made, decisions, and those decisions were based on them not acting reasonably. So let's talk about that. So look, at a fundamental level, the body corporate's always got to act reasonably when making decisions. And acting reasonably means to act objectively, which makes sense, but sometimes that doesn't happen and it doesn't flow through to their decisions that they make. So what is reasonable is always a question of fact, and each case has got to be considered on its individual merits. Now, you can imagine straight away when you've got a situation where a lot owner has a dog and the body corporate said the dog's got to wear a muzzle. There's all sorts of factors coming into play, and you can immediately say, okay, well, what was the type of dog? What was the breed? How old was the dog? Were there, previous...
Was there an incident? Yeah.
Exactly. So all of that comes into play. So let's talk about it a bit, and it'll become apparent here. And hopefully what comes out of this case might help other people if they find themselves in situations, not just in a pet situation, but in a situation where they say the body corporate's acted unreasonably, and what can they do about it?
Yeah.
So this was a medium-sized dog, apparently, and it was 1.5 years old. It was a German Shepherd. So yeah, so there weren't any prior incidents of the dog biting people or anything like that. So the body corporate actually made a decision based on the fact, well, I say fact, based on what they believed, was that the dog was timid, had previously been abused, and there was a risk. There was a risk of biting due to fear, in their opinion, but it wasn't really based on any evidence.
They're just assuming.
It's just assuming. They also said that that's right. They also said in the locality of where this building was located, where it was where they were living, there were there was public transport nearby. Dogs were required to be muzzled on public transport, apparently, and because it was a location where people were frequenting the building a lot, because of the type of building it was, that there would people that would have phobias of dogs. But all of that was just, them surmising. There wasn't really any evidence of any of that occurring. And how would you find evidence of people having phobias of dogs unless they told you, I've got a phobia of dog? And then why do they have that phobia? Could be for other reasons. So there wasn't enough for them really at the end of the day to provide evidence as to, or support their decision as to why the dog should be muzzled. And this is why the lot owner took the body corporate to the adjudicator and asked for interim orders. Now, they asked for interim orders because interim orders can be made on an urgent basis. And you can imagine living in a building, the person's got a dog, the body corporate said he's got to wear, the dog's got to have a muzzle. Owner says, no, it's unreasonable. So while you're living there, what do you do? Okay, so you can go and ask for urgent orders, which is these interim orders that an adjudicator can make. And the adjudicator has got to make orders that are just and equitable, but based on all of the facts of the case as presented.
Now, when you say you talk about urgent orders, I mean, how urgent is urgent? How quickly can something come through in a situation like this?
Yeah, fairly urgent. So when someone makes an application for interim orders and to be done on an urgent basis, they've got to put forward their submissions as to why it's urgent. The fact that he's living there, the fact that there's a decision being made, motions passed at a meeting by a body corporate that the dog has to wear a muzzle. And in this particular case, the lot owner, part of his evidence was, by putting this muzzle on my dog, what you're doing is you're creating this heightened level of stress, not just for the dog, which could have repercussions, but also on him as a dog owner, where he says, I can't restrain my dog or hold my dog as well as what I could without the muzzle. It's creating fear in the dog. The dog's not used to wearing a muzzle. So all of this came out as relevant. And he said, but this is really urgent because they want me to do something. I don't think it's right. It's going to upset the dog. It's going to create all this atmosphere. It's going to be harder for me to maintain the dog as a dog owner. So that's why they did make these interim orders that were urgent. And let's look at what the adjudicator said, which I thought was really, really interesting as to how they came to the decision about ultimately saying that it was unreasonable for the body corporate to make that decision. So the first thing is that what we want to say is that they thought, the adjudicator said, look, it appears that the committee sought to impose this condition, at least in part based on some information provided about the dog and the history, rather than automatically seeking to impose this condition based on the size or breed of the dog. But it really wasn't sorry, phone calls are coming in. It's just thrown me. They shouldn't be able to do that while I'm talking. Okay. But it really wasn't that logical to do that, purely based on, the dog's potential temperament, based on the breed, etc. So really what the adjudicator looked at was evidence that they received from the lot owner, for example, from specialists, from professionals, about the temperament of the dog, the actual temperament, not on a potential temperament of the dog because it was a German Shepherd, for example. So whether it was reasonable to insist on a muzzle as opposed to an alternative, type of restraint, like a head collar, that was mentioned in there. But there was also the question of whether the muzzle would be counterproductive, you see, by generating, as I said before, this greater fear and distress for the dog, with adverse consequences. So a condition of approval can potentially be seen to be unreasonable if the requirement to comply with it is so difficult to be able to kind of comply with the actual condition itself. It would really negate the purpose why it was put in there in the first place. And then it really, at the end, the adjudicator said, look, the applicant, the lot owner, has raised a genuine issue as to whether the body corporate actually failed to act reasonably by imposing such a condition.
And
so,
they were found to not be
and that's right. And there were other dogs in the building that didn't have this condition, that weren't required to wear muzzles, and it was really a bias towards this particular dog and breed.
It's discrimination against German Shepherds. This poor darling German Shepherd, discrimination. And I understand dog, like that it is a larger dog, but like you said, it's not based on fact. There was no incident, and they were putting in as a what if, or so-and-so upstairs said they're a bit scared of larger dogs. It's unfair.
Oh, absolutely unfair. And there was no evidence that by having this condition where a dog had to wear a muzzle, it was actually creating a safety for lot owners. So there wasn't any incidents. There wasn't, as you said, an incident where, you know, the dog was in a lift and it created this fear to a particular lot owner, and there were these complaints coming through. It was just what the body corporate had formed in their own opinion, but there wasn't sufficient evidence. So again, another example, and I will say again, because there's lots of other cases about where bodies corporate have acted unreasonably, and in some cases have acted reasonably. But in this particular case, they acted unreasonably. They barreled forward with the condition without sufficient evidence. And in this case, the lot owner has won with interim orders, which will be reviewed again in 12 months' time. But in any event, that was good for the lot owner. So I guess it's a good case for other people in a body corporate situation to take away if they're in a dispute with the body corporate about anything. Because the body corporate must always act reasonably and must do so objectively. So if they've done so without sufficient evidence on any issue, there's a problem.
Yeah, definitely. And make sure you fight against it if there is. Coming up next, we'll be discussing Bruce Lerman and the Brittany Higgins trial, a trial by jury, and what issues may arise. That's coming up next on Talking Law with Despina Priala. Don't go anywhere.